Good morning, and welcome to part 2 of our series of presentations concerning recent changes to Subpart B of the Standards of Ethical Conduct for Employees of the Executive Branch, what we know as the Gifts from Outside Sources rules. Today, we're very fortunate to be joined by Lee Francis from OGE's Office of General Counsel and Legal Policy Division. He's going to be helping us understand some of the structural changes to the exceptions and also some of the substantive ones to the exceptions we commonly use. If you've not had an opportunity to watch part 1 of this series, it is available on our YouTube channel at youtube.com/OGE Institute. We will also be making the PowerPoint slides for this and part 1 available via listserv after the presentation. So if you have asked us for the slides, we're going to be sending them to everyone as a package along with links to both presentations. So thanks for joining us, Lee. We really appreciate you being here.
Thanks for having me back. I hope this session is as good as the last one was, I hope.
Excellent. Well, I think we have quite a lot to fit into an hour. So shall I pull up the deck and we'll get started?
Yeah, we do have a lot to go over.
All right.
Excellent.
So let's commence part 2.
All right. So again, what we're going to do is we're going to go over some questions from part 1 as I promised, and we've selected a few. Then we're going to go over to Subpart B's, the changes to the gift exceptions, as Patrick already noted. We're going to go over the reasons for making those changes, again, how we intend for those changes to be implemented by you out there in the ethics community, because without you, they will not be implemented. And then finally, we're going to talk about the new gift exception at 2635-204M, which I'll be mentioning quite a bit today, and that's gifts of informational materials. And we're actually going to take a deep dive on that and actually apply that new exception to a few hypotheticals.
So that's sort of brand new, right? That's the big change.
Yeah, that's the big change. There's other portions of exceptions that are new, but that's the real, all the elements there, the whole cloth is new. So I thought it'd be helpful to apply that.
Excellent.
All right, so let's move on. Excellent. All right, so
we had a question that came in about market value, and that is if a gift has a retail cost but is also available from an online marketplace, something like eBay or some other reseller type place, should an employee use the retail cost or the cost from the online marketplace to determine the market value?
Thanks, Patrick. That's our first question, and so I'm going to move on to here. And again, this is where we are now, or at least where we will be on January 1, 2017. Last time I discussed how OG revised the definition to be a bit more expansive. So what I said, and what I'll reiterate now, is for gifts other than tickets, market value under the new rule means the cost that a member of the general public would reasonably expect to incur to purchase the gift. Again, OG did this because some gifts, such as gifts that come in the form of services or intangibles, simply don't have a retail price. Gifts that are bought or sold on websites also may not have a retail price if, for example, they're custom made, like on the website Etsy, or used or antique items that may be available on websites such as eBay.
Would it be fair to say here, Lee, that for those items that do have a retail value, new items that you could reasonably buy at a store, we should be really focusing on the retail cost?
Yeah, that's exactly right, Patrick. And you've led into exactly what I'm going to talk about right here. The answer is, if a gift has a retail cost, that's what the employee must use for the market value. And this is true even if the gift also happens to be available in an online marketplace place for a different price. So some viewers, I don't know if they were confused by this, but I just wanted to go back over it. So again, if you have a specific gift that actually has a retail price, then that's what OG has viewed and continues to view as the cost that a member of the general public would reasonably expect to incur to purchase the gift.
And I think that makes a lot of sense, that we should be looking at the retail cost of tangible items that are new. Just because you get a new item for a discount on an online marketplace or an auction site, that's not the purpose of the market value, right? We really want to find out, what does it normally cost?
Yeah, that's right. And so while OG expanded the definition, to make clear that if there's no retail price, and it would not make sense to ascertain the market value by reference to the retail cost of similar items of like quality, because maybe with an antique, there's just no similar item of like quality. Then, the employee should ascertain the cost that a member of the general public would reasonably expect to incur.
And I think this change in emphasis really reflects our experienced reality over the last 20 some odd years, that I'd say the majority of gifts determinations we make are for intangibles. There are things that people are attending, events, entertainment, services, that kind of thing.
Yeah.
So in those cases, the emphasis on what it would cost in the place makes a lot of sense.
Absolutely. So that was our first question. We'll do the next one now.
So our next question is, if a speaker's meal occurs on the day before or the day after the employee is to speak in their official capacity, may the employee attend the meal under 2635-203B8? So this is the sort of
thread, yeah.
Yes,
the thread that I tried to bring out last time, but I wanted to reemphasize because we got a specific question to confirm on this point. And so the bottom line is the speaker's events that are held on a day other than, the speaker's meals that are held on a day other than the day of the speaking event, if we allowed people to attend those speaker's meals, that would expand the scope of the exclusion and would have the effect of treating speaker's meals differently than other parts of the event. In the preamble, OG stated that's the view, that it's OG's view, the exclusion is a customary and necessary to allow the employee to carry out his or her assignment. A speaker's meal the day after an employee presents is not customary and necessary to allow the employee to carry out his or her assignment, which again is providing a presentation. At the same time, OG notes that speakers' events held on another day might qualify for this or another exclusion or exception or another statutory authority.
And I think that's something we really need to keep in mind here, is that when we're looking at B8, we're talking about an employee on official duty giving an official speech, right? They're in their official capacity.
That's right.
So the gifts rules don't allow the employee to personally accept the speaker's dinner if it's the day before, the day after, unless we use WAG or some other exception.
Yeah, that's right. I mean, they're being assigned to go that day, and if it happens to be on that day, then they can go to that as well.
But if an agency is able to avail themselves of an authority to accept that benefit, they may do so. For example, they could use 1353 if the employee was away from duty station, or they may be able to use their agency gift acceptance authority or some other authority.
Absolutely, nothing would preclude that.
Yeah, so I don't think we're saying that this limitation doesn't say that you can never go to a speaker's meal that happens before or after. It's just saying within the scope of our understanding of this exclusion, it's not appropriate.
That's absolutely right. Okie doke. So there we have it. All right, and this is our last question before we get into the exceptions.
So our final question here is under 2635-205A1, does destruction mean that no one is able to enjoy the prohibited gift?
And I need to change that slide to, I think, 206, and I'll do that before we get it up there. The bottom line is, yes. I mean, the bottom line is yes. If it can be done by throwing away, cutting it up, whatever the case may be.
And I received this question from an ethics official in the field, and they sort of wanted to confirm that when we say destroy the gift, we don't mean place the thing of value in a garbage receptacle and maybe notify a colleague that they might enjoy it. What we mean is that no one should enjoy the gift. Destruction means destruction. We're not in the business of encouraging people to rule beat in this way.
No, I think that's right. And we are just trying to make it easier on everybody. And hopefully we've done that. But again, you can't put it in the receptacle and then fish it out or tell other people about it so that they might want to do that.
And about this change, I think one of the big benefits that you mentioned last time is that it creates a strategy for declining gifts. And I think that's maybe the greatest value, is that, if someone offers you something, to say, I really can't take this. If I did take it, I'd just have to destroy it. So please keep it. Does provide employees sort of a practical strategy for declining gifts.
Absolutely. Absolutely. All right, now we're going to jump into the exceptions. And these are the ones that we're going to go over today. I just want to flag those. And the ones in gold are just like last time, the ones we're going to do a deep dive on. So first, we're going to do a deep dive just on the framework that Patrick mentioned. Then later on, we're going to do the widely attended gatherings, a deep dive there. And then finally, as I said, the gifts of informational materials. So there's other minor changes to the rule that obviously are not here, and I would just invite everybody to refer to the final rule for them. I didn't think that they merited going over today. And then, like I said, we're going to do some applications of the informational materials because I think it's going to be very helpful. So here's where we discussed last week with the prohibitions, and I just thought that that was a good place to start about how OG split the general prohibition on a solicitation or acceptance into two different subsections. Now, OG did that to emphasize that there are, again, in fact, two prohibited activities. And in doing so, OG also sought to address each prohibited activity with regards to, all the exceptions at 2635-204. As such, I want to start here. In essence, OG has changed the language of the exceptions in 204. And I'm going to go over this a few times, and Patrick's going to help me tease it out. Some exceptions are only exceptions to 2635-202-B1 and B2, which is the prohibition on accepting gifts. On the other hand, some exceptions are exceptions to 2635-202-B1 and B2, the prohibition on accepting gifts, in addition to being an exception to the prohibition on soliciting gifts from prohibited sources set forth in 2635-202-A1. However, as I'm going to explain further below, but I will emphasize at the outset, none of the exceptions are exceptions to the prohibition on soliciting a gift to be given because of the employee's official position, and that's found at 2635-202-A2. Finally, I want to mention that this change is not a significant change to Subpart B. All it does is it permits employees to ask prohibited sources for things, certain gifts, in a narrow set of situations in which employees, by and large, already ask for such gifts. I realize that's a bit complicated, so Patrick and I are going to try and unwind that today.
I'm really glad there's a chart.
You already teased the chart, so the chart will be coming up very soon. Okay. So under the new rule, certain exceptions permit employees to solicit and accept gifts, and others don't. However, under the current rule, employees, under our current rule right now, the limitation on the use of exceptions says outright that no employee may solicit gifts. And so that's currently in the limitations on the use of exceptions at 2635-202C2 in the rule that's in effect right now, our current rule. So the next two questions that arise are, first, why did OG make this change? And second, as I've already mentioned, is it really a substantive change? Which the answer is no. First, OG changed this because under the current rule, general prohibition could be interpreted to cover situations it just simply was not meant to cover. And the clearest example is that the solicitation prohibition simply not meant to cover when a federal employee asks his or her spouse, who works for a prohibited source, for a gift that has nothing to do with the employee's work for the government.
And I think, we're coming up on the holiday season here. So I think we've always understood the personal relationship exception to permit an employee who, say, is married to an employee of a government contractor who is a prohibited source. So if your spouse asks you what you would like for the holidays and you name a few items that you might be interested in, this clarifies that that's permissible.
Absolutely. Absolutely. I mean, the personal relationship exception covers acceptance, but OG just didn't intend for that to cover a gift from one spouse or another, merely because they happen to work for a prohibited source. So to ensure that the solicitation prohibition did not lead to absurd results, OG has incorporated an exception to the prohibition on soliciting gifts from prohibited sources, as I mentioned, set forth in A2. And as I'll just reiterate, all that said, this isn't really a substantive change. The same gifts that were prohibited by the current rule are prohibited by the new rule, and the same gifts that are permissible under the current rule are also permissible under the new rule. This just brings a little bit of harmony back to the regulation. And so here's a quick snapshot of the new de minimis exception at 2635-204A. And the changes to the exceptions can be seen here. So for the de minimis exception, employees may never solicit the gift. And this is why, if you look in the second line, the exception says that the gift must be unsolicited. Other exceptions, such as the personal relationship exception at 2635-204B that we just discussed, do not have the requirement that the gift be unsolicited. So to help ethics officials know which is which, Patrick and I have created the chart that he mentioned earlier, and this should make it clear, or at least a little bit clearer, for everybody who's interested in this change.
The chart.
The chart. And these are a listing of all of our exceptions, including the new informational materials exception. The exceptions that omit the requirement to be unsolicited and thus be solicited, may be solicited, should be considered exceptions again, to 2635, 201A1, and only 201A1, which is the prohibition on soliciting gifts from prohibited sources. And this is because of the limitation, the fact that it's only A1 rather, is the reason that that's the case is because of the limitation on the use of exceptions. That's at 2635, 205B. Employees may never solicit a gift to be given because of the employee's official position. And so in essence, there is no exception to that prohibition at 2635, 202A2. So, and this is exactly what that limitation states. I'll just read it very briefly. No employee may use or permit the use of the employee's government position or any authority associated with public office to solicit or coerce the offering of the gift. And that's the bottom line. The employee would violate 202A2 because of this limitation on the use of exceptions. And the last thing we're going to do here is I'll do my best to unpack the application of what we're discussing through the use of an example. So here's our example. If everybody out there, I'll give you 15 seconds just to take a quick read. It's rather short, and then we'll run through this. Okie doke. So this is not a violation of the gift rules because of 2635-204B, the personal relationship exception. First, it's not a violation of 2635-202A1, soliciting a gift from a prohibited source, because you know from the prior slide that a gift under 2635-204B may be solicited under certain circumstances. Second, it's not a violation of 2635-202A2, soliciting a gift given because of the employee's official position, because based on our facts here, we can conclude that Eric did not use his position or any authority associated with public office to solicit or coerce from Ron the pretzel and soda.
Right. I think, folks who have close family members or friends who are technically prohibited sources that they engage with socially often will be relieved by this, because we can remind our friends that it is their turn to buy the pretzels.
Excellent. Yeah, no, that's I like pretzels very much. So that would be great if I could get some. So finally, this exception is to the prohibition on acceptance of gifts in 2635-202B, that is B1 and B2. And if you want to take a look at where we put this in the proposed rule, then it's on 80 Fed Reg 74009. All right, and here it is, the personal relationship exception. An exception to all the prohibitions except for soliciting a gift to be given because of employee's official position. Hope everyone was able to follow us through that change, and that will be the most difficult concept I believe we go over today. So that's why I wanted to get out of the way first.
And I think this chart can be really helpful to us. And if we're looking for themes here, the exceptions that apply to A1 as well as B1 and B2, the personal relationship discounts, outside employment, etc., tend to be exceptions that are used kind of far away from the workplace, if that makes sense. These are things that the environment in which these conversations are going to happen is, you're involved with an outside employer. So you're discussing outside employment and you ask them if they could, take you out to dinner. That makes sense. Right. And I think, in some ways they're necessary for the exceptions to work properly.
That's right. And again, it was just because they're how broadly we wrote them in the first instance that we're just making this, like I said, rather non-substantive change to the way we're reviewing the exceptions. Moving on, so here we have our first set of substantive exceptions, the de minimis exception, the personal relationship exception, which we've already talked about. And for these two, there are rather simple changes to each, and neither of these changes are really new. First, for the de minimis exception, OG is incorporated the guidance it provided in Legal Advisory 15-04, and that is simply that general use prepaid cards, prepaid gift cards that is, may not be accepted under the de minimis exception, as such prepaid cards are treated as cash, and everybody knows that the exception does not apply to, quote, gifts of cash or of investment interests such as stocks, bonds, or certificates of deposit. And second, for the gift exception based on a personal relationship, OG has incorporated into the regulation its longstanding interpretation that employees may not accept gifts, may only accept gifts under the exception from natural persons, live human beings like you and me. Simply put, employees don't have personal relationships with organizations that would justify the acceptance of a gift.
So you can't be friends with a company.
No.
It's not in our view.
Not in our
Not
view.
for purposes of
Not
Subpart
for,
B.
yeah, maybe for other purposes, but not for purposes of the exception at 2635-204B. So moving on, we're going to skip over C and we're going to go straight to D, which is awards and honorary degrees. And OG's made some non-substantive and substantive changes to the exception for awards and honorary degrees. I'm going to discuss the big changes. First, OG reordered the subsection for awards to improve clarity. You'll have to just take a look at the proposed and final rule to take a look at that. But second, OG updated the citations for the honoraries degrees section, which were the citations were out of date. More importantly, OG has expanded the honorary degrees section to permit employees to accept honorary degrees from, quote, similar foreign institutions of higher education. And just to provide some guidance to flesh out this expansion, in the preamble, OG said that a foreign institution of higher education would include an institution of higher education that is physically located outside of the United States if it is accredited by a recognized quality assurance or accreditation organization. So that's the expansion there for individuals that might be approached by foreign universities, have dealings with foreign universities, whether it be at state or who knows, at other agencies that have significant dealings with outside parties. Parties outside the United States, that is. OG also flags for this new expansion, though, that employees need to be aware of the emoluments clause, which could potentially apply to this new expansion, and they need to ensure that that in of itself, the emoluments clause, would not bar what the exception would now allow. Okay, we're moving along at a brisk pace here. So we're moving on to 2635-204E, gifts based on outside business or employment relationships, and 204F, which is gifts in connection with political activities. And OG's made one significant change to each exception. For the gifts based on outside business or employment relationships, OG has clarified by adding 2635-204E4 that employees may now attend receptions or similar events put on by a former employer if three requirements are met. First, other former employees must be invited to the reception or similar event. Second, the invitation and benefits must be based on the former employment relationship. And third, it must be clear that the benefits being provided have not been offered or enhanced because of the employee's official position.
I like to think of this as the retirement party tweak. So, you leave a firm or a company, you come into government service, a colleague of yours from many years back at that firm is retiring. It used to be kind of difficult to find an avenue so that someone could attend that event. And this sort of clarifies, provides a strategy for doing so.
Absolutely. And with these conditions, OG's determined that to be a situation, it's an unobjectionable attendance and an unobjectionable gift. And so you're absolutely right. Covers those retirement receptions, maybe holiday parties, maybe alumni parties or something like that. Then the major change to the Hatch Act gift exception with political activities. It's not a big one, but it says that employees may bring their spouse or other guests when provided in connection with such active participation by a political organization described in 26 U.S.C. 527E. So we didn't change the requirements of the exception. We just added that spouses or other guests may attend if it satisfies all those elements. Okay, so we're going to move on to our second deep dive of the day, which is on the WAG, gifts of free attendance at widely attended gatherings. The changes to the exception received a lot of comments. I believe they received the most comments, and I view the changes as three. There are three major changes that OG has put in place. First and foremost, that everybody's probably aware at this point, after January 1, 2017, all WAG authorizations must now be or will now be in writing. Previously, that was only required, that is the writing of the authorizations when the donor of the WAG was someone who had interest that may be substantially affected by the performance or non-performance of an employee's official duties. And we said, in the preamble, and we said in the final rule that, and we had commenters say this, that it protects the employee, protects the ethics program, and it also protects the sponsor, the person inviting them, that they have a written record of what was considered, and that everybody knows that that person was going, people thought about it.
Yep.
The big flag here, though, is the level of detail that is required to be included in that written authorization, as far as, the multi-part legal analysis. What's actually required to be included in writing, that's really up to the discretion of the agency.
Right. So in cases where you have kind of slam dunk, non-objectionable determinations, we're not saying you have to write a 30-page opinion for each of those. We just want a record that someone's looked at it and it's happened. But of course, if it is a sensitive thing or a close call and you had to think about it, it's good to document your reasoning in case there's criticism later.
Absolutely. Absolutely. So that was the first big point. Now, the second, all WAG authorizations the agencies must make a finding. Again, it's not necessarily required to be in writing, but before issuing the written authorization, agency ethics officials or designees must make a finding in all cases that the agency's interest in the employee's attendance outweighs the concern that the employee may be or may appear to be improperly influenced in the performance of official duties. Under the current WAG rule, as with the writing authorization that I just went over, under the current WAG rule, agencies are required to make this finding only where the gift is from a person who has interests that may be substantially affected by the performance or non-performance of an employee's official duties. So that's where we are under the current rule. We're going to say, with the final rule, it says that must be done for all WAGs.
I was actually sort of surprised that this was a change. I think as a practical matter, we've been doing this kind of thinking about WAG invitations almost all the time anyway. I don't think a lot of people were saying, well, that's not a bad prohibited source, so I'm not going to think about the appearances. But I think this just clarifies that, yeah, you should sort of always be thinking that way.
And I think that's right. And it's just shifting our defaults a bit. Yeah. We ostensibly, you would be thinking about this in all cases, but now we have it there that you should.
Yeah.
And the last major change that I'm going to talk about with regards to the widely attended gatherings exception is related to that finding. OG's provided two helpful new factors for agency designees to consider. And so the first new factor is whether acceptance would reasonably create the appearance that the donor is receiving preferential treatment. And the second new factor is whether the government is also providing persons with views or interests that differ from those of the donor with access to the government. So I think this, ties in our changed feelings about 201B, which we discussed last time, and just really want people to engage in this kind of ethical decision-making and thinking.
And I think it also codifies some model practices or best practices. I think a lot of agencies have been doing this thinking. I know when I was at an agency, we certainly considered these factors when making determinations about events, and having them written in the regulation is a good reminder. And I think it brings consistency to the program.
Excellent. Now, as I said, these are the three major ones. OG did make some other changes to the widely attended gathering, which I'll just briefly mention, but it's not reflected up on the slide. The other thing that I'm going to mention is that OG incorporated guidance from multiple legal advisories that began in 1999. So 99X2, 07X14, and 08X1. Those legal advisories all support and state the position that a WAG must provide an opportunity to exchange ideas and views among invited persons. And I think the way you describe this as a short heuristic is no entertainment. You don't go to a movie. You don't go to a theater event.
There has to be some opportunity for engagement, and not just sitting and watching.
Absolutely. So that's the big changes for the widely attended gathering exception. Feel free, if you have questions, we'll also have that mailbox open at the very end that you can send questions to it if there's something else you're interested about or something that I didn't touch upon that you had concerns about based on this exception. Because again, I believe we got the most comments on the rule in regards to this exception. So this is the second to the last exception that we're going to discuss today, and this is the social invitations exception. And the bottom line is OG's added one new requirement, And before we go into that, going back to our chart, because I think it's handy as well, again, everybody knows, and this hasn't been changed, that the exception here may only be accepted from individuals who are not prohibited sources. So this is one of the ones where the prohibition being broken out syncs up a lot better here and says, well, you can only accept it if it was given forward because of official position, not if it was given or not if it was from a prohibited source.
Whereas before, that was sort of, there was an exception to the exception to the exception.
Yeah, and now we can just point
Now we can just
point and say that one. And so that check is absent, as it were, on the chart that we provided earlier. So the substantive change, however, is that if the invitation is from an organization or if the event is sponsored by an organization, so if either of those are true, the agency designee must do a 2635-201B authorization before the employee may attend. And we talked about 201B in great length last time, but just to refresh everybody's recollection, 201B says that the agency designee must make a written determination. The written part is specific to the 204H exception, that the employee's attendance would not cause a reasonable person with knowledge of the relevant facts to question the employee's integrity or impartiality. And again, that's consistent with the standard 201B.
And I think this provides some harmony between the WAG exception and the social invitations exception. In the old regulation, we had to do all this thinking and analysis to send someone to an event if it was being done as a widely attended gathering. And if it's a social invitation, we said, have fun.
Yeah, that's right. And I think, you're right. It pushes you in one or the other in a meaningful and helpful way.
And here they're more harmonized so that we're emphasizing that the concerns that we have that motivate the thinking we have to do under the WAG, those concerns don't magically go away because you've moved over one part.
Yeah. And hopefully, absolutely. Hopefully, the core of these two exceptions are clear. Right. At the margins, where are we? Which one, but I think you're right. I think this very much helps, even in those margin cases, to know which the core of each exception is aimed at permitting certain activities, certain acceptances. And going back to 201B, the consideration of, declining otherwise permissible gifts, again, the factors there, which are not exhaustive, not exclusive, but we've found to be the most important are four. And that's the value of the gift, how expensive or cheap it is. The timing of the gift. Is it given at a time that, the donor has a business before or seeking to do business with the agency, your agency, the employee's agency? The third one is the identity of the donor, and that's very similar to the timing, but it's whether the donor is what I would call a bad prohibited source, somebody that is affected substantially by the performance or non-performance of the employee's official duties. And then the last one is access. Are you giving disparate or significantly disproportionate access to the donor in comparison perhaps to other individuals, or just other individuals don't even have an opportunity?
I think that makes a lot of sense because we're emphasizing these considerations are important always, right? There aren't certain kinds of events that magically make appearance considerations go away, that make disparate access concerns go away. We really want to be thinking about those all the time.
Absolutely. So the last bit of time we're gonna go for today, which will probably be another 10 or 15 minutes at least, is going to be focused on our new exception, the gifts of informational materials. And so what I'm going to do is I'm going to try my best to go over the reason we have it, the elements, and then we have, I think, 3 hypotheticals that we're going to run through.
Excellent.
And the reason we're focusing here is, I hope it's helpful. Excuse me. It's because, again, this is brand new. So ethics officials would not have applied this to any actual situation ostensibly before January 1, 2017. Okay, so the first thing I want to emphasize, kind of as a prefatory, as a preface rather, is that it's got to be remembered that the new informational materials exception, is a gift to the employee, and it's not a gift to the government. That's how all Subpart B works. So this isn't new, but I just didn't want the lines to get crossed. Gifts to the government, of course, would be subject to agency gift acceptance authorities or appropriations law if an agency has such authority, and we're not gonna get.
And I think that's a really good thing to remember. And a lot of confusion that comes up with the gift rules, where ethics officials, maybe run into difficulty, is failing to make that threshold determination. Is this something that's being given to the government or being accepted by the government? If so, you do your appropriations analysis. And we only go to subpart B when we're thinking about gifts to the employee.
That's absolutely right, and that's the right question to be asked at the outset.
At the outset.
Who are they giving this
Right.
to? Is it for the government to use and to help the agency, or is it actually being given to the head of the agency, or actually be given to the chief scientist or chief enforcement officer or CIO? So as background, the House of Representatives has a similar exception, and OGE determined that creating this new exception was appropriate for a few reasons, which I hope will animate your thinking and understanding of the new exception. And those reasons are three. First, gifts of informational materials are typically given with the goal of communicating ideas and sharing information. They're not primarily given to personally benefit the employee. That's the first reason. The second reason is these gifts, though not to the government, certainly redound to the benefit of the agency and the government, because they're a resource that can assist the employee in making decisions or evaluating policies, among myriad other things that they do or might do in their job. And then finally, OGE recognizes that the exception in many ways accommodates the right of citizens to petition their government, which is enshrined in the Constitution.
Those seem like good reasons.
I appreciate your vote of confidence. So we talked about the threshold question of who's it to the government or to the employee, but now we're actually in the substance. And so this isn't really broken out as an element, but I mean, nonetheless, it is. And at the outset, we simply ask whether the offered gift provides information, which OGE defined on this point quite broadly to include writings, recordings, documents, records, or other, and I would put in similar items based on canons of statutory construction. It's not other items that have nothing to do with the prior list. So I would definitely hew towards and cabin what other similar items might be based on the prior listing.
We're talking about things that exist primarily to convey information.
Yes.
Right. If I wrote some words on the back of a car or something, that doesn't make it informational, right? We're looking at sort of the Aristotelian essence of the thing as information transfer.
Right. And if you have a nice polo shirt that happens to have some insignia on it or some language supporting or saying something, that's interesting. T-shirts, but T-shirts are not informational materials, even if they convey information.
Yeah.
And I realize this is quite obvious, but I didn't want to overlook this point. And as I said before, we're trying to be quite broad, but not absurd in this first point. I guess we're trying to be quite reasonable is how I would say it. So Patrick and I have come up with this graphic here to help everybody understand the multiple moving parts of this exception. And that's what we're going to walk through as far as the elements, and then we'll dive into some applications of them. So the first question is all the way at the left at the beginning of our arrow. And it's basically, if you look at the exception, the gift must be educational or instructive in nature. So the thing that is conveying information must be educational or instructive in nature. And whether something's educational or instructive in nature focuses on the objective qualities of the gift. So textbooks, reference books, research and other academic studies and articles, those are all clearly educational. Those are all clearly instructive. Action films, romance novels, sitcoms are usually not educational or instructive in nature, though I know a lot of people would think sitcoms could be quite instructive. So that's the first element. And the second one is if the gift is, these are all required, so they're all ands, these are all required elements, they all must be satisfied. If the gift is educational or instructive in nature, it still must primarily be created for entertainment, display, or decoration. Not primarily be created for entertainment, display, or decoration. So that's a lot of things will get kicked out, I think, based on this one. And that's something that you want to focus on when employees come to you. An example here is a map of historic DC may be educational or instructive, but if it's antique and it's framed, arguably it's going to be primarily for display or decoration, and that's not going to fit into our exception.
Right. And we could say the same thing for antique globes or I think we know what we mean. The sort
if
of
you're not
things
actually going to be using it for your job, antique books, antique globes, antique maps, they all convey information, and there's certainly reference materials, but it's not something you're actually going to use.
Right.
And that's what we're really interested in. That's a good question, in fact, to ask. Is the employee going to be using this to do their job?
Do you intend to read this and use the information you gain from it to
be a better employer, to
right.
be a better professional, better doctor, lawyer, scientist, engineer, architect, etc. Right. Third, the informational material must have a connection with the employee's duties or the mission of the employee's agency. So I view this requirement as what it is. It's relational and very similar to the definition of related to official duties in OG's prohibition for outside teaching, speaking, writing at 5 CFR 2635 807 A2I. So I think it's not a perhaps perfect analog, but it's a similar
yep.
lens on which to view this element, and it's not something that we're just starting whole cloth that we've never done before.
And I sort of look at this as for boring materials, right? For things that are instructive, that help you work better, right? If it's fun or pretty or will look really good in your office, it's probably going to fall out.
Yeah.
So, that's the goal, is to help employees be better in their decision-making, be better informed. And if these things are moving in that direction, we may be able to use the new exception. If it's fun, entertaining, pretty, or will look really cool in my office, then we're concerned.
That's right. And so the example I have, I don't know if it's fun or entertaining or maybe to certain people, but the Diagnostic and Statistical Manual of Mental Disorders, the DSM, the DSM-5 is the most recent version. It's certainly educational or instructive in nature. It's not created primarily for entertainment, display, or decoration. But if it is given to an employee at, say, the SEC, who works in the enforcement division, because they happen to have an interest in psychology, it's not going to qualify based on our relatedness prong there. Now, if it were given to a doctor at the Veterans Administration, the Department of Veterans Affairs, it would probably qualify for this exception. And that leads me to this last limitation, and that's the less than $100 box. So the DSM-5, when it came out, at least had a retail price of $199. And so this is the last, it's not last in the exception, but this is the last thing I would ask after you've run through all these elements, which are in the definition of informational materials. If an employee at the VA, as I just discussed, wanted to accept the new DSM-5 based on the $199 price, the employee would be required, this is the last element, to first receive a written determination in which an agency designee found that the VA doctor's acceptance of the gift would not be inconsistent with, again, 2635-201B, which is what we just talked about, with the social invitations exception. And again, that's a determination that the employee's acceptance would not cause a reasonable person with knowledge of the relevant facts to question the employee's integrity or impartiality. And same factors there, among others: value, timing, identity, and access. And I just want to go very briefly to the relatedness test, because it's very broad and we didn't have it up on the last slide. And so this is that box 3, whether it's relating to the duties of the employee or the mission of the agency that the employee works at. And so, it basically, if it contains information relating in whole or in part to these categories, which are quite broad, then you're going to have that element satisfied. And again, except for that authorization under 201B, by and large, employees are certainly going to have questions about that, and definitely welcome them because it's a new exception. But, by and large, employees are going to be looking at, and, this exception, they can apply to these facts.
Okay. So it looks like here we have an example. Is this, should we work through this?
Yeah, absolutely. Everybody take a moment. I'll give you a little bit of time. Please read this and we'll take a look at it. And just quickly, the asterisk is to remind everyone that OG is not endorsing this book. Just wanted to say that.
All right.
Okey-doke. So we're going to run through what we just presented to you as the elements. First, definitionally, does the gift provide information? Sure.
Yes.
It's writing.
Yeah.
Definitely. Now to these substantive elements. Is it educational or instructive in nature?
It is.
Certainly. It's a textbook. I don't know that you could have a better paradigmatic example of that.
That's right. Especially if you open them.
and use them. So the second question we have is, was it created primarily for entertainment, display, or decoration?
Probably not. It's a textbook.
Yeah, it's a textbook, and I guess you could construe it as being entertaining to some people, but in any event, for purposes of the objective person and the reasonable person.
And its purpose is to inform. It's not to entertain.
That's right.
Right.
That's right. Finally, the next one we have is, does it relate to Laura's duties or the work of the EPA?
It's a textbook about the environment, and she works at the Environmental Protection Agency. I think we have the nexus covered.
Excellent. Excellent. And sorry, that's the third substantive element, but we always have to ask, was it greater than or less than $100 in value? And I want to note that it's whether or not the specific gift is greater than or less than $100 in value, or whether all informational materials that the employee received from that one donor in a calendar year are greater than $100 in value. And this goes back in many ways to the aggregation idea with the minimis exception to 204A.
Right.
So you can't give a bunch.
If you have one source, they're sending you a $95 book once a week.
You have to start doing it.
We have to start doing it once we hit the $100 ceiling.
Exactly. And I might not have mentioned that before, and that's in the rule. So obviously, if one informational material is over 100, you're already there. But if multiple over the course of a year you do the same type of aggregation you would for the 204A de minimis exception, and you would have to do the 201B. And it's in writing, it has to be a written determination.
And I think this makes a lot of sense, because if we're looking at particularly the access element of 201B, if we're getting a lot of information from just one source, there is maybe a danger that they are misusing this element to unduly influence an employee. We just want to make sure that we think about it.
Not only that, but it's certainly currying favor with more expensive manuals.
Right.
I think that's another fact. They might not have access to these otherwise, and there's books on securities and there's books on other areas of law that are $2,000-$3,000, and so we definitely have this restriction here for that reason. And then the other thing we also mentioned, and that we had a question about or a comment about that animated this requirement, was people potentially reselling these informational materials that have exceedingly high values.
And then you could be using your public office for private gain. And
rule reading and among other things.
Yeah.
So that's what that's there for. And it's just a gut check, a reasonable restriction that we put in there. So we have our second of 3 examples, and I'll also give everybody about 15 or 20 seconds to take a look at this one.
For a second earlier, I thought you made a mistake. I said, this is just like the last one.
Again, OG's not endorsing Tron Legacy.
All right, I think I got it, Lee.
All right, wonderful. So this one I think is going to be much shorter than our last analysis. Same question, definitionally, does the gift provide information?
Yeah, films can and do convey information.
Certainly. Sometimes it's educational, sometimes it's instructive, sometimes it's not. So yes, definitionally in the layman's sense, and that's what we're really getting at with this broad first question, is it a gift that provides information? As you said, it certainly does. So now to these elements. Is the film educational or instructive in nature? What do you think?
I don't think so. I'm not sure what it would be helping us learn to do. The Trombach said maybe we could read it as a manual for, I don't know.
It's certainly futuristic and it's certainly creative, but objectively, it's a sci-fi film. It's not
educational.
Instructive in nature. So right then and there, we would fall out of the exception. Right. It's pretty clear. And so it's a pretty easy example. And that's why I included it. Why, when employees would come to you and ask if they can accept entertainment films because they provide certain information, at least in most cases like this, clearly it's going to fall outside the exception. And this also, double back with the second element, which was it created primarily for entertainment, display, or decoration? Again, it's quite clear here. The answer is yes, it's created for entertainment.
Okay.
So we clearly fall out there. And we'll finally move on to our third and our last example of the day. And we'll give you a moment to take a look at that, and I'll come back in about 15 or 20 seconds. Patrick's noting that I forgot to put the asterisk. We are not endorsing Rachel Carlson's Silent Spring, and I will also include that before we provide out.
All right. I think I got it.
I think we got it.
I think we got it.
Excellent. Definitionally, again, does the gift provide information?
Yep. It's a book.
It's a book. It's a writing.
That's what books do.
Absolutely.
Mostly.
Absolutely. So to our elements, is this book educational or instructive in nature? I haven't read it.
I haven't read it.
I've heard it's a great book, and from my understanding of it, it's a book on environmental science and about the effects of pesticides. So it would be
educational or instructive
in nature.
Great.
The second question is, was it created primarily for entertainment, display, or decoration? And I mean, it's a first edition. And so between this and the first and second one, I think in certain situations, you might have some questions to ask. Are they actually going to be using, it might be educational or instructive in nature, but I think that gets back to, are they actually going to be using it
right
and as an educational or instructive object? Well, and if they're not, then
I think about, very old versions of the dictionary. You have beautiful old bound dictionary that you could put on a stand in your office, and it's going to look amazing. Well, I think we have to look at, is this really a work that's going to help you or instruct you, or is it something that you're just going to look at from afar and enjoy?
That's absolutely right. And I think that, maybe not here, but in other cases, it's always something you have to be aware of. Right. Is it really just a present? Is it really something that's really valuable that, that is worth a lot of money? That's an antique.
And I think that the motivation for M is to allow people to receive information, not to receive valuable objects that may or may not contain useful information.
That's absolutely right. And it's kind of putting the cart before the horse, or throwing it ahead of itself. So it wasn't created primarily for entertainment or decoration at the time, but as we just talked about, what we're really trying to get at with educational and instructive, the animating principles are, is it going to help them do their jobs?
Right.
And then finally, the question, the third one we ask is the related to this question, which is really why I included it as the third example. Does it relate to Laura's duties or the work of the SEC?
Probably not.
No. Laura here works in the enforcement division. Securities, pesticides, environmental degradation, and environmental science fall outside of the agency, the agency's mission and her duty specifically. So we stop there. We don't have to go on. That relatedness test is not satisfied. And those are the examples that we have for you today. And that's the substance of the materials that I have. I've got 8 minutes left. So thank you all for attending. Again, I'll mention that some of these topics discussed today, such as the WAG, the changes to social invitations exception, and the informational materials exception, will be examined in OG's forthcoming legal advisory on the changes to Subpart B. So please stay tuned for that. We would also very much like for you to send us questions, if you have them, about perhaps parts of the rule that we discussed today. And it's my intention that, Patrick and I will discuss those and either get back to you directly or potentially get back via webinar or some other forum.
And I think, just to wrap up this series that we've done on Subpart B and the changes in general, it seems that we've really, both structurally and substantively, put the focus of Subpart B where it belongs, and that's on protecting the integrity of agencies' work and the integrity of employees' contributions to that work. Subpart B isn't about getting stuff. It's really aimed at making sure that we don't accept things that would harm the agency's reputation, the individual's reputation, or the work. I think if we keep that in mind, all of these changes really fit together nicely.
No, I think that's absolutely right. I mean, I think objectively, if you ask the simple question, do government employees, they're accepting gifts build the integrity
Right.
or the impartiality of employees or government officials? Does it increase that? The answer is by and large, no.
Right.
And does it potentially damage that? The answer is by and large, it can.
Right.
Now we've come up with some unobjectionable exceptions, but that's our starting place.
Right.
It's not those unobjectionable exceptions kind of
Right.
like putting forth the way that you should think about the rule.
No, I think that really clarifies things, and I hope folks keep that in mind as they implement these rules in their agencies and train on the rules. So thanks, Lee, very much for joining us,
Sure.
and thank you everyone for joining us. And we hope you will join us for future broadcasts. And again, if you have questions, please send them to us. Enjoy the rest of your week.